directly to give you answer. If you have any question, please feel free to call me at the number on the screen. You can write a comment below the live video. I'll give you answer. Someone asked me in my last video that how long someone can stay in Pakistan. It depends on your immigration status. If you are a British citizen, you can stay in Pakistan as long as you can. If you are a settled indefinitely to remain, you can stay outside the UK highest, but not more than 2 years. If you stay outside the UK more than 2 years, your indefinitely to remain will lapse, and you will be required to apply for a returning residence visa, and it will be depend on the Home Office to issue a visa or not. So it is important, if you have ILR, you should return back to UK before complete 2 years outside the UK. Another issue also you will face if you want to apply for British nationality after you got ILR, then you have to satisfy that in last 1 year you was not outside the UK more than 90 days, or last 5 years you was not outside the UK more than 450 years. So it is important that you should apply for first British nationality, and after that you can go to outside the UK. If you are normally to remain, you shouldn't stay outside the UK more than 6 months. I hope you got your question. I don't know your immigration status right now, but if I know your immigration status, I will give you the correct and exact answer which is applicable to you. Next question. I have a friend to the question is asked Mr. Jamal Kamal. I have a friend in Nottingham. His 20 years will be completed in January 2021. Does he need to pay the Home Office fee for applying ILR? Mr. Jamal Kamal, thank you for your question. Your answer is yes, you will be required to pay the Home Office fee, which is ILR, indefinitely to remain. Currently, the Home Office fee around £2,354, and I think if you are in 20 years in UK, on what ground you will apply for ILR? This is a question what I need to know, because if you are on normal leave to remain, or if you don't have an immigration status, then after 20 years, if you make an application under human rights law, you will apply for a limited leave to remain on the basis of your private life, that is 20 years long residence. In that case, this is not ILR, this will be a limited leave to remain. ILR you will apply after completed long residence, which is either 10 years or if you are on 5 years road. Now, if you applying on limited leave to remain on the basis of your private life, that is 20 years long residence, you may get a fee waiver. In that case, you need to make an application to the Home Office, fee waiver application. And if the Home Office accept your application, then in that case, you don't need to pay any Home Office fee. To get fee waiver application or to successful application to Home Office, then you need to satisfy that you are destitute. Now, definition of destitute means those people who doesn't have enough money to pay the Home Office fee, or does have money to pay the Home Office fee, but they don't have enough money to pay rent or daily essentials. So if you can establish you don't have enough money to pay the Home Office fee or NHS fee, you should make an application, which is fee waiver application, to the Home Office. And if the Home Office satisfy, then they will give you a exemption from paying the Home Office fee. Next question. Ibadullah Khan, you asked me, I need to apply for a visa extension for my wife. She has done B1 when she applied for her initial spouse visa. Can someone tell me whether she need to redoing the B1 or is valid for lifetime? Thank you, Mr. Abdullah Khan, for your question. Your wife did a B1. B1 is not for lifetime. It is only for 2 years, valid for 2 years. Now, the immigration rule says if anyone use the B1 certificate or satisfy the English language requirement in any of his or her previous application, then on a subsequent application, the applicant doesn't need to satisfy the English language requirement if the Home Office accept your previous English language certificate in his previous application. I don't know when she used it, but for example, if someone apply for ILR, indefinitely to remain, and someone used the B1 certificate because ILR requirement as well be B1. So you use the B1, and after 2 months or 6 months later, 2 year expired. So that means your B1 certificate expired. Then after 1 year or 2 years later, or any time you applied for a British nationality, and at that point, again you need to satisfy the B1 certificate English language requirement. The immigration rules said, as you previously in your indefinitely to remain application, you satisfy this requirement. That's why you don't need to satisfy the same requirement again. The Home Office will give you an exemption from British from English language certificate subsequent application. That's what immigration rules say. So if your wife used this B1 certificate in her previous leave to remain application, in that case, she doesn't need to satisfy again. Thank you very much, Mr. Abdullah Khan, for your question. Next question, Naima, you asked me, hello, dear sir, is visit visa application. What does this email mean? Is it a visa approval or it was refused first, then submitted JR, then what is this email? Thank you. I think the email is self-explanatory. The email itself explain it. This is basically an email from the from the BFS that to collect your passport. So this is nothing about a decision. This is just information that your passport is ready to collect. Thank you very much for your question. Next question. Hi, friend. I'm a non-EU family member, and now my wife in Romania. Can she apply for pre-settled status from Romania? Thank you, Mr. Ali Akbar, brother, for your question. You asked me. You are non-EU family members, and your wife lives in Romania. Your question is, can she apply for pre-settled status under EU settlement scheme? Yes, your wife can apply for pre-settled status from Romania because pre-settled status under the EU settlement scheme can make application from inside the UK, which is leave to remain for pre-settled status. If someone wants to apply from outside the UK, this will be leave to enter pre-settled status. So your wife can make an application from Romania for pre-settled status. The same procedure, that is, she needs to use EU exit ID to verify her identity, and then she can make an application, and the Home Office will issue pre-settled status. Your solicitor, Sohail Ahmed. If you have any question, please feel free to give a ring on the screen, the number at appeared on screen, or you can write a comment. I'll give your answer. So next question, Kish, you asked me, I have submitted my fee waiver application online. I just want to ask where to send document by post or by email. Thank you very much in advance. Thank you, Kishwar, for your question. For fee waiver application, you have two options. Either you can send your document by email or you can send by post. Now, when you submit the application, when just finally submitted, and the final page, I think this is in section 7, when you submit it, then there is a page come where it said you can now send the document. And over there, there is a email address, and it said that you can send it to this email. You need to mention your UAN number on the application, 16-digit number. In the subject, you can write the UN number, and then you can attach all your supporting document, and then you can write a cover letter in the email. So you can send by email. If you cannot upload it, or you can upload it attached to the email, then you can send it by post as well. The decision will come within 6 weeks, highest 6 to 8 weeks. You will get a decision on your application. The second question you asked me, my visa will be expire next month. If I don't get the decision, what should I do? Will I be an overstay? Or will I make the application for leave to remain? You don't need to make any application because your leave to remain will continue until you get your decision from the Home Office about your waiver application. What you can do, you can wait. Once you get your decision, you can straight away make the application, prepare all the documents, because you will get only 10 days after the decision come. And right now, the Home Office is giving decision by email, so keep checking your email address and spam folder regularly, because you will get only 10 days. Within the 10 days, you will get a code, and you need to use this code within 10 days. If you cannot use the code, your visa will expire, the code will expire, and you will be an overstay. So very careful when you deal this case. Check your spam folder, email address, and then once you get the code, immediately make the application within 10 working days. 10 days, excuse me, not 10 working days. Next question. Wahibul Hassan, I have a judicial review hearing on to get back in country appeal right. My case is certified. Can you advise me what is the chances and better barrister? Unfortunately, I cannot recommend anyone in live video, but the chances is depend on your case. I think if you show your file to someone else, then someone can advise you accordingly. And then next question, Haidar E. Karar, you asked me, I'm planning to apply my wife's spouse visa from Pakistan, but I'm living here in London. Has one room where bills are included. It's a share accommodation. Please tell me it will work out Home Office point of view. Shall I go for a new separate apartment? Thank you, Mr. Haidar, for your question. Your answer is the Home Office requirement is you must satisfy the accommodation requirement. If the applicant get visa, if she comes to the UK, you must able to accommodate her. And the requirement is the house must not be overcrowded. So if you are living a single studio flat, that's fine, you satisfy the requirement. But if you are living on a shared accommodation, that what in your case, and if more people living on other room, the definition and explanation what is overcrowded in the Housing Act. So the house must not be overcrowded. If the rest of the room people are living either one person or couples, that will be fine. You satisfy the requirement. But if the home is overcrowded, then you will not satisfy the requirement. I think I can advise you to speak to a surveyor. There are a lot of surveyor they can give you a certificate that whether the home is satisfy the requirement of overcrowding or not, or whether satisfy the requirement of immigration rules. So it will be a good idea to get a survey report and a letter from a surveyor. So that's what will be a good idea in each situation. But if you can afford a studio flat, that will be a brilliant idea. As you want to apply for your wife, if she get visa anyway, you need a studio flat probably to live together. And in that case, if you make a tenancy agreement, that would be brilliant. I think that's what I would suggest. But obviously, if you're living in a double room and if the whole house is not overcrowded, that will be satisfy the requirement as well. And next question. My friend is inviting using IDP app. He has also an option to go for biometric. what option is the best to go with, IDP app or biometric? I'll suggest to go to the appointment, biometric appointment, because IDP app is very technical, and it will take around half an hour even just to take your picture. The IDP app is not working fully, not functioning fully. Although it will show you that you are saving some money, but in practically when I use this app for my own client, it's taken an hour to verify and complete one application. Uh, when you take the picture, it cannot recognize. You need to turn it right, left, front, back. That way, it takes a long hour to complete the application. So if you have an option to go to biometric appointment, that will be my suggestion. Thank you very much. Shahjad Memo, you asked me, I just want some help. I'm on FLR-FP, British wife, 10 years route. My visa expired in October. I need to apply for second extension. What document do I need? Which forum I need if I want to apply myself? Can someone help me, please? Thank you very much. You need to make an application FLR-FP. So if you Google it, you will get FLR-FP. There is no form that you can download it. What you have to, you need to make an online application if as you are in the UK. So just Google it, FLR application, and then it will take you the right window, and then give your email address, a memorable password, and then you will start filling up the form application. When you will go to the main form, it will explain you what kinds of application you are going to make. So it will say leave to remain on the basis of your private and family life. Now, what kinds of document? You have to give the same document as you used in your previous application, because previously 2.5 years before you made the same application, that is FLR-FP, you apply leave to remain on the basis of your private and family life with a British wife. If you have a children, again the same document. So same document. In brief, you need to provide evidence of your identity. You need to provide evidence of your relationship. You need to provide evidence of your accommodation. You need to provide evidence of your, if you have children, their passport. If you have any also employment document. These are the basic documents you need to provide. The home office fee, which is currently £1,054, you will be required to pay. In addition to that, you will be required to pay the NHS fee. If you cannot afford to home office fee, I'll advise you to make an waiver application in advance before your visa expires. If you're lucky, you'll get an exemption from paying the home office fee, as well as probably you will get access to public fund, because normally your BRP said no recourse to public fund, but if the home office give you from exemption from paying the home office fee or NHS fee, in that case, most of the cases, the home office give access to public fund, that is your BRP will be recourse to public fund. Thank you very much for your question. Next question, Mr. Max Fine. You asked me, a British national who passed away had a wife and son in Pakistan. His son was born in Pakistan and is 2 years old. He was in the process of applying visa for his wife and children to join him in UK, but unfortunately died in road traffic accident. Is there any chance where son and wife make British citizenship? Max, thank you for your question. The son can register as a British citizen. So under the immigration rule, under the British Nationality Act 1981, Section 1, the son can register himself as a British citizen, as his father was a British citizen and he was born outside the UK. So under the Nationality Act 1981, son can register himself as a British citizen. Now he will be required to prove that he was the son of that person who passed away. Generally, if the father would alive, he could use his birth certificate, and the father could give a statement. Unfortunately, as the father passed away, so it will be very challenging. But again, other way, DNA test, which cannot be done right now. However, still, if he can make an application using his father naturalization certificate, British passport, and his birth certificate. If the Home Office refused, probably Home Office refused, because if they suspect, then you need to, if they refuse, you need to challenge it by way of judicial review. And in that types of case I dealt with, and in my experience, what the Home Office do, Home Office normally straight away go to the local authority, check with, in Pakistan, check with their local council, that is a union council, about the birth and death register. There are some volume, some process in Pakistan. They check that there, they go there, they check, investigate locally, and then if they find that this is a genuine relationship, normally they issue a British passport that is registered as a British citizen. Also, if they refuse unreasonably, you can go to the court, and I have win same such type of case from Home Office in the High Court by way of judicial review. So thank you, and good luck for the couple, for the mom and son. Next question I have received. Udas Ahmed. Dear sir, this question is for my friend who is an EU national having UK permanent residence. Want to apply a visa for parents as a EU extended family member. Do his parents need TB test report for this? Please ask, give me my answer. Thank you very much for your question. Your question is default question. If your friend is a EU nationals, and if he want to apply for his parents, it shouldn't be extended family member. Parents are family member. Extended family member and EU family member, two different things and two different regulations. EU family member under regulation 7, which is first your wife, your partner, your children, your dependent children, your dependent parents. So the chances of to get visa EU family member is more higher than extended family member. In extended family member, you need to satisfy a lot of requirement, and still chances are 50-50. But family member application, if you can satisfy all the requirement, is granted. One of it has to issue visa. So your parents is family member under EU regulation 7/2016. You should make an application as a EU family member, not extended family member. And now I'll go to your answer. Whether EU family member or extended family member need to do TB test, the answer is no. Short-term visa applicant, for example, if someone come to UK for visit visa, they don't need to do TB test. EU family permit is a short-term visa, which is for 6 months. Therefore, it doesn't require TB test. First, they will I'll take an answer, and then I'll come back to you again. Yours, please ask your question.
Hello, Assalamualaikum.
Walaikum assalam.
Can I speak to Bangla?
বলেন ভাইয়া।
Very simple. যদি বেশি আমি আমার ছেলে বেসিসের উপরে আমি টেস্টটা যদি বই আপনার কত দিন লাগে যেমন রেজাল্ট নর্মালি জানা
বায়োমেট্রিক দিলেছেন
জি দিলেছি
আপনার বাচ্চা কিটা ব্রিটিশ না 7 ইয়ার্স?
জি ব্রিটিশ।
জেনারেলি 2 থেকে 3 মাসের ভিতরে হইলেইব। আগে আপনার করোনা ভাইরাসের আগে 2 মাসের ভিতরে হইলেই তো, এখন একটু লেট করে করোনা ভাইরাসের লাগে বুঝছেন। সো 3 মাস 3 থেকে 4 মাসের ভিতরে ইনশাআল্লাহ ডিসিশন পাইলিব।
আচ্ছা দিন পেশা আমি আগে 6-7 বছর হচ্ছে ও গ্রাউন্ড উপরে বইছি তেমনি আগে ভালো চান্স আছে আমার।
6-7 বছর আমি বুঝছি না। আপনার বাচ্চা ব্রিটিশ না হইছে?
জি ব্রিটিশ।
ব্রিটিশ হইলে তো 6-7 বছর গ্রাউন্ড। ব্রিটিশ বাচ্চা যদি থাকে তাহলে আপনি FLR FP application করছেন on your family life with the British child. সুতরাং
Yeah.
chances is 100% unless there is exceptional circumstance. আপনার যদি সবটা ক্লিয়ার থাকে দেন ফ্যামিলি রাইটে বাচ্চাদের ব্রিটিশ রাখে ভিসা গ্রান্টেড দিতে হইব তারা যদি দেয় না আপনি চেঞ্জ করতে পারবেন সেকেন্ডলি আপনি একদিনের প্রিমিয়ার অ্যাপয়েন্টমেন্টও দিতে পারতেন আগে একদিনে ভিসা আনতে পারলাম
বাট এর সময় এই ডেটটা আসেন না ভাই, 1 মাস আগে, 2 মাস আগে, 1-1.5 মাস আগে প্রিমিয়াম।
so
সে সময় আসে
chances are not very good inshallah আপনি ভিসা পাইবেন
জি ভাই সব দোয়া হবে ওই সব বুঝছেন।
thank you very much
থ্যাংক ইউ স্যার, জাযাকাল্লাহ খাইর।
Yes, I was speaking about EU extended family. So, what was my question? I'll take a question from Facebook that is Mohammed Abdul Qadir. Can work for more than 20 hours on Tier 4 visa? Not more than 20 hours. Abdul Qadir bhai, thank you for your question. Tier 4 student visa, you cannot work more than 20 hours. If you do a graduate course, you can work up to 20 hours. If you do any postgraduate course, again, you can do up to 20 hours on term times. When holiday period, that time you can work full time, whether 100 hours or 60 hours, doesn't matter. You can work full time. Other than the holiday period, you can work only 20 hours. Also, for your information, I think probably you know about it that from the 5th of October, new immigration rules is coming for international student from 5th of October. That is, all the international student will be subject to new immigration rules, including EU student or non-EU student. And once any international student completed their graduation or completed their course, whether 1 year or 3 years, they will get 2 years work permit. They will be able to bring their dependent visa when they will be in that work permit. The dependent as well will be able to work full time. Their spouse, their partner, their dependent children can come to the UK, and after the 2 years work permit, they will be able to switch any other general work permit. So new work permit is on its way. So from the January 2021 post-Brexit immigration fund, that is the work permit is coming. Under the new work permit, I discuss a lot, but just a brief information that you need to work only, you need to achieve or get 70 point. And if you get 70 point, you will get new work permit. I'll back to the work permit immigration rules later again. But before that, I'll take one question. Angel, by is child maintenance mandatory? Will it support my parenthood visa? Child maintenance is not mandatory, but what is mandatory is your relationship with your child. So if you have a British child or a child who got leave to remain or has a right to live in the UK, you must have a genuine relationship with your child. Genuine relationship, that is love and affection, because in many cases, Court of Appeal, the appeal judge said that you cannot use your child as a trump card, exactly in their word, you cannot use your child as a trump card to get leave to remain in the UK, to get visa in the UK. So you have to be very careful. You cannot use your child to just get the visa. There must be a genuine relationship with your child. If you are separate from your child, if you are separate from your wife and you don't have access to your child, you will not get visa on the basis of because you don't have a relationship. So you can apply making child arrangement order in the court, and once you get a court order, you can use the court order as the evidence of your relationship, access to child. I hope you got your question, your answer. Thank you very much, viewers. If you have any question, please leave your comment below, or you can call me directly on the number appeared in the screen. I'll give you answer. Muhammad Nabi, you asked me, hi, call me please. I want speak with you. Please call me on the number at the screen. I'll speak with you. The number is 0203239596. Please give me a ring on that number and I'll give you answer. Thank you, Muhammad Nabi. You can call me. I'll speak with you. Next question. Muhammad Gauri, you asked me, can you help me? I want to know what is the types of FLR partner visa, type A, type B, type C. I have received same types of question before. There is no types in FLRFP visa. FLRFP visa itself a route. There is no category type A, type B, type C. This is a Canadian immigration, the US immigration system. I'm a British lawyer, and I'm discussing about British immigration rules. Next question, Baby Jones. You asked me, my friend got leave to remain last year and looking to apply for British citizenship. Does she need to go to B1 test? Thank you very much. She got indefinite leave to remain last year. If she satisfied the English language requirement in last his or her ILR application, right now she doesn't need to satisfy again. I gave the same answer before. Now some people can get ILR without satisfying the English language requirement. For example, if someone is asylum seeker, their family member of an asylum seeker, they doesn't need to satisfy the English language requirement at their ILR application. So they can apply without any English language certificate and they will get indefinite leave to remain. However, when they will apply for British nationality or British citizenship, that time they will be satisfied the requirement of B1, that is English language requirement. So if your friend who got ILR, if she doesn't or he doesn't satisfy the requirement of English language in his or her ILR application, right now she will be required to satisfy this requirement. When she will apply in the form, the question will come, have you ever satisfied the English language requirement? If yes, then the question will not come next that do you have any certificate? But if you click no, then the next question will come, do you have an English language certificate? Next question. Mr. Usman Ali, you asked me, my friend is a EU citizen, live in UK, want to apply for settled status. He don't have passport at the moment. Can he apply with his national ID card? Yours, I'll give your answer after a short break. So Mr. Usman Bhai asked me that someone want to apply for, I don't know why all of the question coming from the friend. Someone want to apply for settled status. He doesn't have any ID passport. Can she apply for national ID card? The answer is yes. If you are a EU nationals, then you can use your ID card to verify your identity. But if you are a non-EU nationals, unfortunately, your national ID card will not be sufficient because most of the non-EU ID card I saw is not recognized by the EU Exit ID. That is the app what we use to apply for a settled or pre-settled status. However, you can use your BRP card. You have a biometric resident permit, so you can use your BRP card to verify your identity. You don't need a passport. Okay. In the BRP card, you can scan it by the new exit ID, and you need to leave the reference number. in the top right corner, the BRP resident number, you need to use this number and the system will verify your identity. So your answer is, if you don't have a passport, you can verify your identity by using BRP card. Thank you very much for your question. Next question, Angel Bai. I'll take a question first. Yours, please.
Hello?
Please.
Oh, yeah, I'm just watching the live.
Yes, that's correct.
Are you speaking yourself or is this someone else?
Yes, I'm speaking. You can speak with me.
Okay. It's regarding my sister. She sent me the video. She's watching your live on her phone. We want to ask basically her husband and her separated. He went to apply for a domestic visa because he thought that was the best option for him to get a visa, but obviously that didn't happen. He then went on to apply for parent visa, but that's taking quite a long time. They haven't made a decision yet. So she obviously doesn't want a child to be used for his visa application. But the child is also disabled. And it took him 1 year after to see, so he was going to get the visa on the domestic route. After 1 year, he applied for the child contact order, but they haven't made a decision yet. So, what is his chances? The child is also disabled.
Please, I don't get your question. Can you repeat the last bit again?
Sorry?
Can you repeat the last bit? What is your question?
She wants to know whether do the Home Office investigate whether the child is being used for the parenthood application or not. If so, how would they find out?
Okay, I'll give you answer. Okay, so Home Office will not investigate this matter. Okay, because the Home Office look at what evidence you gave at the application when someone make the application. That is, if it is a domestic abuse, that obviously there is a court decision. So Home Office will look at the court decision, social care report, or if any other agency involved, that what Home Office will look at is. Home Office will not look at or investigates this matter, because if investigation is already done when the court make a decision, because court look at the evidence and made a decision. So if any judgment or court order in favor of the applicant, that's what the Home Office will look at.
Right. So she has mentioned to the court that the only reason why he's applied for contact is so he can use application. So would they?
Yes, please go ahead.
The court recognize that the child is being, I would call it, abused for his purposes.
Yeah, I do understand, but you need to give this argument to the court, because obviously family court will make a decision, and what are the findings of the family court will be final, and Home Office will make a decision on the basis of family court determination. All right.
Right.
Thank you very much, madam, for your question.
Thank you.
Thank you.